Hello viewers, welcome to this brand new program where we talk about immigration law in the UK. My name is Primrose. I'm a solicitor specializing in immigration law. You might ask, why talk about immigration law? Well, the answer is simple, really. Immigration law is quite a hot topic in this country. If you watch the news, you will also be aware that it is quite an important subject to the current government. The government has been bringing in reforms into the system since 2012. So this area of law has become quite complex, but because it affects a lot of people living in the UK, AILTV has come up with this program so that we can help viewers to know what's happening in the world of immigration and to just raise awareness on these issues because they affect quite a lot of us. Please be aware, however, that this program is not intended to provide legal advice in people's individual cases. If you are affected by any of the issues discussed on this program, please seek advice from a professional. If you'd like to talk to me, you can contact me at info@ailtv.com. and I will respond, or you can contact me using my details that are appearing on the screen right now. So as an introduction to this program, we're going to start by talking about the recent developments in immigration law. As I said, there have been a lot of developments since 2012. So today I'll talk about the recent developments that have been introduced by the Immigration Act of 2014. It's just by way of introduction, really. In future programs, we'll get to talk about the different categories of visas that people apply for. But for today, we'll focus on the Immigration Act 2014 and what it means for people. As I said, it's a very significant piece of legislation. And the reforms that it brings are in stages. Some of the provisions are not yet in force. Some of the provisions are already in force, which means that you'll be affected as of now. As we are speaking, it is already law. I'll indicate the provisions that are in force and the ones that are not in force. To start off with, I'll talk about the new removal powers that have been introduced by the Act. The Act has given the Home Office new powers to enforce removals much easily than in the past. The reason why the reforms have been brought in is because it was taking long for the Home Office to effect removals, and they were getting quite frustrated about that. That is because the current regime requires them to follow stages before they can actually effect removal. It means that the Home Office would have to write to the person formally to inform them that they intend to remove them. And then once a person receives that notice, they will be allowed to appeal and go through the appeals process before they can be removed. And because the appeals process is in stages, it took years in some cases, many years before removal could be effected. So what the Act has done now is that it has removed all these rights of appeal where a decision to remove a person is made, which means that for a lot of people, when that decision is made, they cannot appeal against the decision. I'll give you an example of the people that will be affected. If a person is in the UK without valid leave to remain, they can be removed without the Home Office taking any further step to enforce removal. In practice, it's likely to mean that the Home Office can just arrest a person, they can turn up at their home, arrest a person and take them straight to the airport. Or if such a person is encountered by the Home Office, they can be removed without any further notice. Family members of those affected as well will be removed along with the person subject to removal. That is quite significant. As I said, at the moment, people will be able to challenge the removal by way of appeal, but under the new provisions, they will not be able to do that. Now, these provisions are not yet in force. It's not quite clear yet. The government hasn't given an indication as to when these provisions will come into force, but it can be any time now. The other reforms are regarding appeal rights. At the moment, under the current regime, a lot of people can appeal against Home Office decisions where their applications are refused. But under the provisions, the new provisions, appeal rights have been abolished for most types of applications, except for applications where a person has made a human rights claim or a claim for international protection, otherwise known as an asylum or humanitarian protection. If your application is not a human rights application or an asylum or humanitarian protection application, you will not have a right of appeal under the new provisions. People like students or people applying for leave to remain under the points-based system for employment purposes will not have a right of appeal where the application is refused. That will be quite difficult for a lot of people, because if you can't appeal, how else are you going to challenge the Home Office decision where you are refused? Well, there will be one option, which will be judicial review. You can apply for judicial review. However, judicial review is a more complex process, and it is costly as well, and lengthy. So it's not an ideal process to go through. But because of the new provisions, a lot of people will not have a choice but to go for judicial review proceedings. Of course, you can go back to the Home Office where they've refused your application and ask for administrative review, but it's likely that the Home Office will not change their mind. Therefore, judicial review will be the only viable option. A lot of other changes have been introduced. The ones that I have been getting a lot of inquiries about are regarding access to essential services. What the new Act has done is that it has tried to restrict the access to essential services for a lot of people, especially those who are undocumented. And when I say undocumented, I am talking about people without valid leave to remain. Those who are here illegally and those who are here as overstayers. They will see that their access to essential services has now been restricted. Yes, this is because the Home Office has introduced, well, it is actually Parliament, not the Home Office. It is Parliament which brings out these laws. So Parliament in this case has imposed statutory duties on certain bodies to restrict access to services for people without documents. For instance, we've got DVLA. Now DVLA has a responsibility to work with the Home Office and not to issue driver's licenses to people who have no valid stay in the UK. Already they've started cancelling driver's licenses for those that were issued and who have no leave to remain. So now under the Act, they are obliged to cancel the driver's licenses that were issued to people without valid leave to remain. Those without valid leave to remain will not get a driver's license from now on. They are working with the Home Office so they can check when you apply whether you have leave and whether you do not have leave to remain. So there is no escaping that one. If you have a driver's license and your leave runs out, you are likely to find that DVLA will revoke your license after your leave to remain has expired. So it is important to make sure that you continue to renew your status so that you don't lose your license. And if you don't have status, take steps now to regularize your stay. Another authority that will be working with the Home Office now is the NHS. They'd already started restricting access to the NHS for those without status in the UK. The government has gone further to introduce a levy that people will have to pay for them to access NHS services. So when a person applies to the Home Office for leave to remain, there will be an extra charge to pay for use of NHS. This is on top of the Home Office application fees. They are going to add another amount that you pay that will cover your use of the NHS in the UK. Those without valid leave to remain, already you're not supposed to be using NHS without paying for it. You have to pay for it unless you fall under some exceptions. For instance, people who have pending asylum applications can fall under the exception. And then we also have private landlords who now have statutory duties not to lease their properties to people who have no valid leave to remain. So under the new Act, landlords have to check their tenant status. If the tenant has no leave to remain, they are not allowed to rent a property in the UK anymore. If a landlord proceeds to allow a tenant to rent a house when they have no evidence of their status, there is a fine that they will have to pay. So for landlords, they have to seek advice as well before leasing out their properties. Other reforms, like I said, the act is very lengthy, so it's not difficult. It's not easy for me to go through it in detail on this program because of our time. But what I'm just doing is just rushing through it just to let you know what this act is all about. If you need to go into detail about this, then you can contact me using the details on the screen. Otherwise, you can also seek advice from a professional. The other reforms are regarding British citizenship. Now, these reforms are quite significant because in the past, what you had was if you had British citizenship, you were safe. The Home Office could not touch you, but not anymore. The law has been changed so much that now the Home Office might be able to deprive people of their British nationality. This will be done where deprivation of citizenship is conducive to the public good, because the person, whilst having that citizenship, conducted himself or herself in a manner which is seriously prejudicial to the interests of this country. So for those committing serious crimes, the fact that you are a British citizen does not mean that you are untouchable. They can deprive you of your citizenship. That is quite a significant change in the nationality laws, which will affect some people. So the advice is, do not commit any crimes. This country already has enough criminals, so they are trying by all means to make sure that they get rid of as many foreign criminals as they can. As I said, this is just the beginning of the programs that AILTV has in store for you. In future programs, we'll go into detail about the different categories of visas that you can apply for and the requirements that you'd have to meet when you make these applications so that you can get the visa. We will talk about student visas, we will talk about spouse visas, we'll talk about applications under the points-based system, Tier 2 applications, Tier 5 applications, Tier 1 applications. So keep tuned in for the future programs. If you like more information, please contact me at info@ailtv.com and they will forward your inquiry to me, or you can contact me on my number, which is appearing on the screen right now, or on my personal email, which is also appearing on the screen right now. Keep tuned in. Thank you.